Good afternoon, and thank you for tuning in to our Facebook Live today. My name is Courtney Johnson. I am a senior attorney here at Atlanta Legal Aid and the Family Law Intake Coordinator.
Good afternoon. My name is Nilu Abdi Tabari, and I am a staff attorney with our Domestic Relations Unit here at our downtown office at Atlanta Legal Aid.
So before we get started, just a couple disclaimers. This is a general presentation about Georgia law, and it may not directly apply to the facts of your case. Every case is different. And so for more specific, detailed advice about your individual situation, we advise that you contact an attorney for an individual consultation. This presentation does not create an attorney-client relationship, and the information is about Georgia law and Georgia specific. And so if you are viewing from a different state, we recommend that you contact someone in your own state for more information.
And just very quickly, our mission statement here at Atlanta Legal Aid is that we help low-income people meet the needs, meet their basic needs, and removing barriers to justice through providing legal assistance.
So today we are going to generally go over some key topics, a little family law 101 when it comes to the issues of child support and custody. And so we will start with a little bit of conversation about legitimation. So if you are unmarried to the mother of your child when your child is born, the mother has all of the rights to the child. And so in order for you to be known as the legal father, you're going to need to more than likely file a case in Superior Court. Now, legitimation means that you would be known as the legal father of your child so that your child could inherit from you. So for example, if something were to happen to you and you had an insurance claim, your child could then receive insurance money because of what happened to you. Now, legitimation can be done in 3 different ways. So the first way, we no longer do it, but it used to be a thing called administrative legitimation. And that is where at the time of your child's birth, you signed a document saying, yes, I want to be this child's legal father and known as their legal father. Now, if your child was born after June 30th of 2016, more than likely you have not signed this because that is the last date that we ever had that be possible. If you have a copy of that document that you signed, that is wonderful news. If you do not, it is possible to try and get that from Vital Records. It can be a difficult process, and so it may also just be easier to file a legitimation case. And that's the second way to legitimate it, is to actually file a case in Superior Court. You're going to file that case in the county that the mom of your child lives in. There are some exceptions to that, so you also may want to consult an attorney just to make sure. But you would file that case in Superior Court and ask that a judge sign a final order saying that you are the legal father of your child. And with that, you also can ask for some custody or parenting time with the child, and we will talk about that in more detail a little bit later. Another way to legitimate your child is to marry the mother. So if your child was born and you all were not married at that time, but later on, 2 years later or 1 year later, a month later, got married, then your child is legitimated. Don't need to go to court or anything like that for you to be the legal father of that child. Now, one of the key issues that you want to consider when filing a legitimation case is actually being able to know where your child's mother lives. It is really common to not really have an idea of their address, but it's difficult to file a case without knowing where they are. Think about it as if even if you were to get a final order that said you had some time with your child, if you don't know where that child is, it's difficult for you to actually have that time and go and pick up your child and spend time with them. So before filing, we recommend that you really try to figure out an address for them. Another big issue with legitimation is people don't always know you really do have to file this case to have time with your child and have a final order saying, here's when you'll spend time with them, here's who make choices for them. So if you have a child support order that you are paying on every single month, a judge has signed an order saying you need to pay this amount of money every month. That does not guarantee that you have legitimation rights and you have rights to see your child. You are obligated to pay child support because you have a child here in Georgia. And so again, you're going to need to go ahead and file a legitimation case. If you sign their birth certificate, you were at the hospital, you were supporting the mom, you signed the birth certificate, so your name's on it, that again does not mean that you were the child's legal father. If you had a DNA test, so you had a child support case, a DNA test was given during that case, or you took an at-home DNA test, and the child is biologically yours, that still does not mean that you are the legal father of that child. You will still need to file a case. You could be seeing your child all the time, every week, every weekend, holidays, all of that. That does not mean that you are legitimate and that you are the legal father of that child until you have a court order saying so. You could be just paying for your child for items for them. You could be sending over clothes, sending over diapers, being very supportive financially. And if you still don't have an actual case that has been filed with a final order, you are still not that child's legal father. And so you will need to file something in order to become a legal father and then also ask for some parenting time or custody of that child.
Okay, so with that, let's talk a little bit about custody. So as Courtney already addressed, custody can be addressed in a multitude of family law cases, one of which is legitimation. The other types of cases where you customarily see custody come up is a divorce, a separate maintenance. We already said legitimation. There is a new action in Georgia, an equitable caregiver action where custody can be addressed. And custody can also be addressed on a temporary basis in a family violence protective order. So you want to keep that in mind as well. I often refer to it as a divorce light, so it can address many of the issues customarily addressed in a divorce. So what do we mean when we talk about custody? So here in Georgia, we define custody in two different ways. We have physical custody and we have legal custody. And while they are two distinct things, they overlap in terms of how they work with each other. So what is physical custody? Physical custody is exactly what it sounds like. It's how time is apportioned between the two parents, parent A and parent B. And that can take different forms, right? So it could be primary physical custody. And what that means is that one of the parents, the child spends more of its time with one of the parents than the other. The remaining parent will have what we call a parenting time, or historically known as visitation, with that minor child. But one parent will get a greater amount of time with that child. There is also joint physical custody. And joint physical custody is when the child's time is apportioned equally between the two parents, parent A and parent B. So oftentimes you see parents asking for different things. And joint physical custody is something that you constantly see coming up in cases. Just want to give a few caveats and some issues that tend to arise when we talk about joint physical custody. So things that you want to take into consideration: the proximity of the parents. How far away do you live from each other? Are you living in the same county? Are you living in the same school district? Is one parent living in Henry County? Is one parent living in Fulton, right? If you're trying to apportion the child's time equally, how is that going to work with school, right? Because it's going to leave one parent driving a child to school and out of school in what is likely going to be a long distance. So is this actually physically possible? Is this actually in the best interest of the child? Joint physical custody typically means a lot of communication between the parents. You're going to have to work out complex schedules, extracurricular activities. It's just going to be a lot more interaction. So that's another thing you want to take into account. Is that feasible? A lot of parents are not in that place, and a high level of communication really just means a high level of animosity. So that's typically not in the best interest of the child or the parents. You want to think about what is realistic. right? Think about your current situation. How is parenting time currently apportioned between the parents, and what is actually physically possible for each parent? If you have a parent asking for joint physical custody and yet spends 2 or 3 days a month with that child, are they actually going to be able to spend 50% of their time with that child? It's not always a want thing. We may want things that just aren't physically possible. So again, you want to be thinking about what is realistic and what is actually going to work for both the parents and for the child. And you want to make certain that you are planning into the future. If you have young children, maybe children who haven't entered school yet, then you need to take that into consideration. Is this a plan that is going to grow with you and your children and your family? Is this something that is going to be feasible when the child starts school? Should you decide on joint physical custody now while the child is young and outside of school, are you still going to be able to accommodate that schedule once the child is in school? So you consistently want to be thinking about what is realistic, what is currently working, and what will continue to work. On that same note, you have to take into consideration legal custody of the minor child. And legal custody is about decision-making regarding the child. And this is over 4 main areas. We have extracurricular activities, education, religion, and non-emergency medical decisions. And joint decision-making can often be divided, and the language looks very much like physical custody of the children, right? So is it one parent that's making these decisions? Is it joint legal custody? That means that the parents are going to have to interact with each other. They are going to have to communicate with each other, and then ultimately come to a decision. And then what do you do if you cannot come to a decision? So often in joint legal custody, which is what most judges sort of lean towards, is that the parents be involved regarding all of these decisions, but someone has to be the final decision maker if the parties cannot agree. And this is where you start to see some overlap with physical custody. If one parent has primary physical custody, then it would just make sense that that parent retain final decision making, because it's going to impact that parent's life more than it will the other. So let's give some examples of what that would look like. Let's talk about extracurricular activities. If parent B has every other weekend, let's say with the child, that's sort of a standard parenting time that everybody's familiar with, should that parent be scheduling Bob's ballet classes during parent A's time, right? What if it doesn't work with parent A's time? What if parent A is working? What if they can't accommodate that with their work schedule or something else that's going on? Or what if that extracurricular activity is too far away? What if the cost doesn't work? So again, you start to see how this decision-making overlaps with the physical custody of the child and how it can impact that parenting time. So again, always when making these decisions regarding physical custody as well as legal custody decision-making regarding the children, again, you want to be grounded in what is realistic and what is going to work for each of the parents. So on that note, when we talk about these arrangements, when we talk about physical custody and legal custody, how is this captured in a family law action? Well, these things are captured in what we call a parenting plan. And the parenting plan is where you sort of lay out what this is going to look like. So one of the things I always like to point out is we are used to that standard language of every other weekend, and then there's a dinner somewhere in there when we're talking about one parent having primary physical custody. It doesn't have to be that, right? You can make it what works for you. So ultimately, I always say the parents can come together and make a decision regarding these issues. And ultimately, if they can't, then a judge will make the decision for them. The benefit of coming to an agreement is you can fine tune it, right? You can make this really meet the needs of your family and your children and each of the parents. It's sort of the difference. I sometimes use the example of a plastic surgeon versus an ER surgeon, right? You're just going to have a little bit more detail when you're working with a plastic surgeon versus an ER surgeon who is just trying to sort of save the life versus focus on all the minute details, right? So in a parenting plan, you can address everything in detail, right? So we've just given a very broad general definition of what physical custody and legal custody look like. But in the parenting plan, you want to go into a lot more detail. You want to think about, where are you picking the kids up? Where are you dropping the children off, right? No matter what the custody or parenting time arrangement looks like. Is that safe? Right? Is there safety precautions that need to be taken into account? Can the school accommodate it? What do you do if school is not in session? Is this a realistic plan? Communication. What does that look like between the parents, right? Is this something that should occur via phone calls? Is it via text message? Is it something that needs to occur on email? Or there are parenting apps available now, like Our Family Wizard, that can accommodate communication and schedules for the children. I always say you want to treat that parenting plan like a worst case scenario plan, right? This is sort of your emergency plan. If you and the other parent cannot get along, right? It's designed for those moments where you cannot communicate and you cannot get, this is your backup plan, right? If the house is on fire, this is your evacuation plan. So this is what you fall back on. You can always work outside of that parenting plan. If parent A and parent B can come to an agreement about working outside of that plan, then you most certainly can do that. You just want to make certain that you understand that it is for those moments when you cannot come to an agreement, that this is what you are going to fall back on. And you always want to remember that should you come to an agreement or a judge grants a final order regarding parenting time or custody, that if there is a material change in circumstances, right? Let's say parent B decides they're going to move to Virginia, and now that parenting plan needs to change to accommodate that. Then you can file what we call a modification. And a modification would need to be filed in the county of the other parent, and that parent would need to be served, and you would have to appear in court to either come to an agreement regarding those issues and or to have the judge make a final decision. I always say, if this is something that is pending, you want to make certain you get these modifications filed as soon as possible. Court cases take time. Filing a case takes time. Getting in front of a judge takes time. Presenting evidence, gathering evidence, decisions regarding what's in the best interest of the child don't come quickly, right? So again, make certain, especially if it's time sensitive, that you get that modification filed as soon as possible when there's a material change in circumstances, so that can be addressed. With that, let's talk a little bit about child support and how that comes into play after a custody action.
So every parent is obligated to pay child support and financially support their child if they have a child here in Georgia. This is regardless if that parent is legitimate or not, there's still an obligation to pay child support. And child support basically takes into consideration your income. So it's going to be looking at the income of both parents. It's good to think about it as if you all were living together in the same home, you would have two incomes coming into the home. And so, how much would you spend on that child is kind of what the thought process is with that. In Georgia here, we use a child support worksheet. And the child support worksheet, it's like a calculator. So you will input your income and the other parent's income and a number and how many children you have. Number basically spits out about what child support should be. Now that number can change a little bit depending on your certain circumstance. So if, for example, if you are paying a child support order for another child, if you have a court order saying that you owe child support to this other child and you are paying on it for at least 12 months, that goes onto your worksheet for your next child. And so that number of child, that amount of people that you pay is going to be a little bit different. Other things that can come into consideration on a child support worksheet are things like insurance. So if one parent is paying medical insurance for the child, if there are daycare or childcare costs for the child, that also can come into play and be considered to be a part of the child support amount that's paid monthly. If there's generally just low income on one party's part, that can be considered about, how much child support is to be paid. And then also if you are in a court case where child support is at issue, when you all can come to an agreement of what child support should be, that can also be considered on a child support worksheet, and that can be mentioned there of why this amount is a little bit different than what the worksheet says.
So just like briefly to sort of recap is that, with child support, you've got some basic information that you need, right? You need the income of both parents, and some basics is going to be who's paying for insurance, right? What is the child care situation? Is that going to change in the near future? Are there other child support orders out there? This is just very basic information that can be used to get you at a number. There are both adjustments and there are deviations that can take that child support number up, or they can take that child support number down. Ultimately, child support worksheet, it is a calculator. It is an Excel spreadsheet, right? So it runs a formulation. Typically what people are arguing about and what makes it more complex is when you're trying to establish the incomes of both of the parents. And so let's say one parent has a small business, right? Usually deriving an income for that parent can be incredibly difficult. Sometimes childcare is going to be, it's not sort of the standstill thing. It's a moving target, right? Like it's going to change as one parent's work changes or as the child enters school. So again, with child support, usually the complexity is not the calculator itself. That's really about inputting numbers. It's really going to be that sort of evidence gathering and presenting that's going to get you at the numbers that need to be input into that child support worksheet. That is usually where there's going to be some disagreement for the parents. One thing I always want to point out, which is very strange with child support worksheets, but often parents are sort of arguing, trying to pull each parent's income a little bit higher, right? And one of the things to always remember is that as the parent's income goes higher, that base child support number is actually getting higher as well. That means that it doesn't mean that the child support obligation is going to go up. So you have to be careful about how you are arguing those child support numbers. A lot of times it's going to create an impact that we don't always realize. So, and always remember as well that income can be imputed. So let's say a parent is not working, right? We all know we have the coronavirus. We've been in a state of emergency. It's been difficult for many parents with childcare and many other issues to work. But minimum wage can be imputed to a parent. In their former income can be imputed to a parent. So you should always know that there is a lot of complexity and remedies, which is why legal advice and assistance and potentially a consultation with an attorney is going to get you a lot further than just sort of leaving the situation.
To just reiterate to what Nilu mentioned earlier, when filing like a modification, for example, of child support, you really do want to consider what everyone's incomes were before in the initial child support case and what they may look like now, if your child has different needs now than they did then. Because a modification, you could be filing it saying my income has decreased and I really need to pay less child support. But if the other parent's income has significantly increased or decreased, or if the child's needs have increased or decreased in terms of like daycare or after school activities or other kind of medical things that the child may need, your modification may actually go up once you file it. So it is possible to go on the Georgia Child Support Worksheet website and just kind of play around with numbers there. And you may want to do that before filing anything, just to make sure that the case may possibly go in the direction that you're actually wanting it to go in.
And I think we have a couple of questions. I guess I'll start with the first one, and this is not it doesn't look like it is a child support question, but it's a more complex question. So this is a question regarding a parent that moved, it looks like out of state with the minor children, and the parties are married. So again, this raises a host of questions. And so what I'm going to do, rather than providing advice, because we would need far more information to be able to provide advice. This is where getting a consultation with an attorney, and we'll provide Elena Legal Aid's information shortly. But questions that you'll need to ask yourself is where the parties were residing before everybody moved, right? How long has the other party lived out of state with the minor children? Think about what are the remedies that you are seeking, right? Is it a custody action? Is it a divorce? Are there other issues at play? Especially when you're married, it's just a little bit more complex. You are likely not going to be addressing the custody issue in a vacuum. So you have to think about what type of action you want to file. You want to think about timelines. You need to think about counties and exactly what the remedies are that you are seeking. So definitely when you're looking at that kind of complexity, that is definitively, you need to speak to an attorney so that you can get the right information about what to file, where to file, and what your remedies are. And then do you want to take the second question, Courtney?
So the second question is a little more towards child support. So if you marry someone who has younger children and they are paying child support for that child, would the income of you as the person that was married to someone with children come into play when calculating child support? And the answer to that is no. So a child support worksheet is looking only at the incomes of the legal and or biological parents. And so step parents or other people who may be in that household, their incomes are not considered at all. Now, as a parent, if you are taking care of a child in your home, that you are legally obligated to take care of that child. So if you are taking care of a child by a different father, that kind of thing, then you can consider that child as someone you take care of, and your child support obligation may be a little bit lessened. But as a step parent or someone who is married to the other parent or someone else that's in that household, generally your income is not taken consideration at all. So it's just about the incomes of the two parents.
And this is where you see a lot of sort of complexity start to come in. Again, this is sort of where the sort of arguments come to play when it comes to child support, and that is what gets included as income, what doesn't get included as income. So like another example would be typically means tested or income tested benefits that you are receiving are not counted as income either, right? So again, one of those things to take into consideration. So there's a lot of complexity at times to what can be used as income and what cannot be used as income. And that's, again, why it's good to speak with an attorney and get that advice to ensure that the numbers that are being inputted actually capture the true incomes of the parents and the benefit. And again, with a reminder that child support is about the benefit of the child. It is not about the benefit of the other parent. So to ensure that the child is receiving the benefits and the assistance that our laws have deemed necessary.
And child support comes up in several different types of cases. So mostly for dealing with children. So legitimation, any kind of other custody action, a divorce, a separate maintenance, which is pretty much a legal separation here in Georgia, that would come up there. A mother can file a paternity action on her own in Superior Court, asking for the biological father to pay child support, as well as to open a case with child support services. And then they would do the kind of heavy lifting for you to file that case and get a child support order.
And a TPO as well. So again, if you need to file a protective order, if you file a family violence protective order, Child support is one of those issues that can be considered and can be granted. So again, something you want to take into consideration. And I'll sort of use that to sort of caveat us right back to where we started, which is remember that a child support action in and of itself does not establish rights to the child. So in particular, when we have parties that are not married, if dad has not legitimated the children and the parties were never married, then filing a protective order and seeking child support is not going to grant dad rights. Going through child support services to establish child support, even when there's a DNA test done, is not going to establish rights. So always remember that you can pursue that remedy. And if father seeking rights or obtaining rights is a concern, if there's a safety concern, just remember that in the absence of that legitimation action, it does not establish rights to the children or child.
Now there are, if the other person has a child support order and they are not paying it, there are a couple things that you can do. One of those things is called a child abandonment warrant, and that's filed in magistrate court. And that's basically asking the judge to say that they have not supported the child within the past 30 days. And at that time, a judge can order them to pay an amount of child support kind of immediately. There is a risk of some jail time as well without paying that child support amount. Another way to do that is to file a contempt, and that's saying that there is a child support order in place and that person is not paying it, and therefore they are in violation of that order. And again, you're asking for a judge to order them to pay. So that could look like a couple different things. The order can be that they pay at a certain amount by a certain deadline. The risk to that, if they don't pay for the deadline, could be some jail time. The judge could have a general order that says they have to pay a little bit more child support to kind of make up for what they owe. And there are other remedies too. It's really kind of at judge's discretion about what the remedies could be, but that's one way to try to receive child support if the person is not paying it. And also if you have a case with child support services, so you have taken your order to them and they're registered you as someone who they help to serve, they have ways as well to kind of motivate someone to pay child support. One of those ways is to suspend their driver's license. Another way is to, if they have any money in terms of returns for taxes, they can take that and to read that to you as well. So they have their own set of motivation to get people to pay as well. So there are a couple different things that you can do if someone is not paying on that child support order, or to try to establish that. Another key tool is called the income deduction order. And that is an order signed by a judge that is then given to the person who needs to pay the child support to their employer. And so that employer will take a certain amount of money for child support out of their direct paycheck to read that to child support services. And then child support services will then give it to the parent who has custody of the child and is receiving that child support.
And one of the things that I always try to bring up in terms of, I'm actually I got distracted because we have another question coming in. So let's take the question and then we'll see if I can remember what I was talking about a few moments ago. So the question is regarding, this is actually a point that Courtney brought up, and unfortunately it is a very common issue. And that is when a father is trying to file a legitimation action to establish themselves as the biological and legal father of a minor child, but they cannot locate the mother to serve her. So there's some advice that we can provide, and this is going to be different for each person. One may be if you know where the other party works. So you need the address for two reasons, right? You need the address, one, to ensure that you're filing in the appropriate county. Because if you file in the wrong county, even if you get the other party served and you end up in front of the judge and they're like, I don't live here, right? I actually live in DeKalb County. I don't live in Fulton County. Then the judge may be forced to dismiss that action. And you're going to have to go and refile and potentially pay more filing fees. And we'll talk about that ways around that in a moment. So you want to certainly take that into consideration. The second reason is service, and that is because a sheriff or a private process server needs to hand the other party the documents, right? Not their mom, not their aunt, not mail it to their mom's house, right? So one could be hire a private process server, right? And sometimes with a picture or some basic information, like I have some clients who may be able to say, I know where the individual lives. I know the apartment complex. I can kind of narrow it down, but I don't know the exact apartment number, right? A private process server, I mean, they're going to charge you, and you want to make certain that you have a process server that is certified for that county, but they may be willing to go knock on each door and see if they can find that individual. You may be able to provide them a picture, and they may wait at the entrance of the complex or the home to see if that person comes in or out. Or if you have the address of mom, of the other party's mom, and you know that they go there regularly, the private process server may be willing to go there to be able to hand them the document. So a private process server is willing, typically, of course, at a fee, to do a lot more than a sheriff is going to be able to do. And that's not a slight against sheriffs. They just have a lot more on their plate than just serving. So typically they are going to go out to a location, they're going to knock on the door, and they're going to see if that individual is available. Be very careful about using, a lot of times I notice people are using like mom's address, right? And if the sheriff goes out there and mom is like, this individual doesn't live here, guess what? The sheriff is not going to go back to that address, right? So I would say, one, do you know where this individual works, right? A sheriff, you can provide that to the sheriff or the private process server and see if they're willing to go out there to get that individual served. Just make certain that you have the county that you're filing in right, okay? So it's okay if mom lives in Fulton and works in DeKalb, you can take a copy of the paperwork to a DeKalb County Sheriff's Office and see if they're willing to serve her at work. Hire a private process server. See if you can get information that way. Check social media in a safe way. You certainly don't want to be stalking someone, but if there is information that you can obtain, then that might help you at least narrow it down, right? Make certain you're filing in the right county, and then see if a private process server can maybe come in terms of honing in on location. Unfortunately, they do charge. If you know you need to file in Fulton, then, and I'm just using that as an example, then contact the Fulton County Clerk's Office. They should have a list of process servers that are certified for Fulton County, and make certain you are working off of that particular list. And then
I would just say publication service is a thing. And so that's where you're putting notice that you have filed a case into a legal newspaper for the county that you're filing your case in. Essentially recommended for someone, if you don't know where the child is, to file that way and to get them served that way, because you'll end up with a document that could say you have some parenting time or custody of this child, but there's no way to actually see the child or have notice of the other parent. I really would only recommend doing it that way is if the child is actually living with the father. So for example, the child's living with the father, it's been with the father for several months or several years, and then mom has just kind of jumped off the face of the earth. Like no one knows where mom is, there's been no contact with her, she hasn't made phone calls, or, we can't find her on social media or anything like that. And so in that case, because you actually know who the child is and you want to make sure the child's interests are taken care of, and you can, enroll them in school and the doctor and that kind of thing. And so in that instance, going ahead and filing legitimation as the father and letting the judge know, like, I have no idea where this other parent is, and so can I put the publication notes in the newspaper? And basically just says you have filed this case on this date, and then the other parent, the mom, would have a certain amount of time, so 60 days from the day it's first starting publication, to basically be able to say that she sees that she wants to argue about it. But if she doesn't, then the case can kind of proceed. You can ask for a final order for custody. But again, if the case is that you don't have a child with you, we really do recommend trying your hardest to find an address. Looks like we have another question. asking is if it's possible to get a minor child's last name changed if the father has had no contact with the child, besides a court-ordered child support, that it looks like it's not necessarily paid monthly. Is on the birth certificate. So it is possible to get a minor child's name changed. The court generally is going to want the other parent to consent or to at least have knowledge about that case so that that parent is served with the documents that saying that this name change has been filed. However, in Georgia, there is a law that allows a parent to ask for that name change, even if the other parent has not been involved. So if they have basically not been involved with the child for 6 months or more, you could say that the parent has abandoned the child and kind of therefore abandoned their interest in what this child's name is. And so a judge can agree with you about the abandonment. It's just a matter of letting the judge know kind of the last point of contact and seeing if the judge agrees with you in order to let that continue so that you can get that final order with the name change for your child.
I did want to sort of come back to a couple of things. And this is some confusion that I notice sometimes when we get phone calls. Always remember that Child Support Services is an enforcement agency, right? So essentially you are taking them the child support order or getting a child support order established through them. And even though you're getting it established through them, remember that it is a judge that is granting that child support number. So they come in and they essentially provide assistance with obtaining the child support amount. So when it comes to something like a contempt, when you have a child support arrearage where the other party is not paying, if you have signed up with Child Support Services, then you actively need to let them know that you want to file a contempt, right? They're not going to take these actions sort of absent a request or communication from you. So, and a contempt is basically saying, I have a court order for child support and the other party has not been abiding by that court order, so they are in violation. So typically a court is going to calculate an arrearage, which is to say, let's say the person owes $1,000 and they're going to add a certain amount on top of that child support amount to get that arrearage paid off. Now, you don't have to only pursue this through Child Support Services, right? You can go to the court and you can file it individually as well. So you have those two avenues in terms of filing for that contempt, which is to calculate an arrearage. Now, a modification comes in when you need that child support amount to change. Now, this is a really big, this is a big issue that we see coming up, right? Let's say as a parent, you have a child support obligation and you lose your job, right? Again, we've been living during a time where that is commonplace. So courts and the judges and court orders don't automatically find out, right? There's no automatic thing that lets them know that you have lost your job and you are no longer able to meet this child support obligation. So that child support arrearage, or the amount that you are not paying because you cannot, right, is just going to continue to build until the other party files a contempt. And let's say you wait 6 months and then you file a modification. Guess what? That amount that built over the 6 months is something that you are going to be obligated to pay. A modification cannot retroactively go back and then change that amount from, let's say, the day that you lost your job. Now, it can work from the day that you filed your case, right? That's why it is imperative that if you have a major change in circumstances, your income goes down, you lose your job, and you have that child support obligation, get that child support modification filed as soon as possible, because that is the only way to stop it from continuing to build and then becoming sort of an insurmountable hurdle. Another thing you need to keep in mind is if you have a child support obligation and someone goes to you and says, I went to Child Support Services and said, no more child support, right? That actually does not get rid of the child support order, right? That may terminate their services that they contracted child support services for, but it does not get rid of that child support order and the amount. So you could be going by 5, 6, 7 years thinking that you and the other parent have worked it out. You came up with an agreement that your case is closed. And then suddenly you find out that you have some huge arrearage, right? And now you and the other parent aren't getting along. And now that parent can go after that child support arrearage. So as a parent with a child support obligation, always make certain you are protecting yourself. If you lose your job, get that modification filed. If you and the other parent have come to another agreement, get in front of a judge and get that order changed so that it reflects the actual agreement. Because unfortunately, when you file a modification down the road, it's not going to be retroactive. So just keep that in mind as well.
And Neela mentioned arrears as well. And if you have a child support arrear, so that there is a running number of how much you owe for child support you have not been paying or not been able to pay, you will owe that amount until it's paid. And so your child can be, over 30 years old with their own set of children, and you will still owe that child support amount that you were unable to pay or did not pay when that child was under the age of 18. So just keep that in mind. That could mean that you have some taxes taken that you might have gotten refunded to you. That can mean you're filing Social Security. Social Security check is also now being garnished and taken out from that check and given to the parent who had that child when they were a minor. So that number will follow you until it's fully paid.
So sort of, I guess, maybe in wrapping up, we did want to discuss that if you need to file an action, if you need to file a divorce, a separation, a legitimation, any type of family law action with the courts, there is a document, and we both decided we hate the name of the document, right, but it is called a poverty affidavit, and each county has their own specific poverty affidavit. And what this document actually is a request to the court to waive your filing fee. So often that's another hurdle that our clients may face when trying to seek legal remedies, right? And again, it's one of the hurdles that at Legal Aid, we want our clients and to be able to overcome. So that poverty affidavit is a request to the court to waive that filing fee, which can be significant. It can also alleviate the service fee in terms of the sheriff. In some counties, it may also alleviate mediation fees, right? So, or a parenting class that you may be required to take. So it can have a lot of impact on a case. Now, typically what you're going to need to do is get that document, may be available online for some counties. You can call the clerk's office, say, hey, I need a poverty affidavit. How do I get access to that? You can call Legal Aid. We're going to give you our number, and hopefully we can give you that information as well. You're going to complete that document, and you've got to get in front of a judge to get it signed. So a judge gets to say, yes, I think you meet the requirements for this fee waiver, right? So every county has a different process. In some counties, you file it, and then the judge is going to send you an order saying they have signed or they have not signed. Some counties, they may be able to do it on the spot. Also, COVID has impacted how counties are handling poverty affidavits as well. Some counties may not have any judges in the courthouse. They may be handling it via Zoom, right? You may need an appointment to get that poverty affidavit addressed by a judge. So just give the clerk's office, the Superior Court clerk's office, a call, see where you can get a copy, see how you can get in front of a judge. And if a judge signs that order saying, yes, you qualify for this fee waiver, they'll sign an order, and you're going to take those two documents, and you are going to, I typically recommend, go in person to the clerk's office and file it with your documents, and it's going to alleviate that filing fee for you. So don't let that filing fee be a hurdle to receiving or getting access to the family law action, like a legitimation or a divorce or a protective order, which actually have no charge. But if you need any of those things, then seek out that poverty affidavit so you can overcome at least that first hurdle in filing.
And generally, several different counties also have forms available for you to file for legitimation or for custody or for a divorce on their county website. An example of that is the Fulton County Courthouse has forms at fultoncourt.org, and several other counties also have forms that are available there. I know that I believe we will put in the chat the Georgia Legal Aid website, and it has also plenty of links and also some videos that kind of explain how to file and what can be filed as well. So we do recommend doing a couple searches online as well, just to get those forms that you might need.
And just, I guess, in closing, so just to let you know, this video will remain available on the Atlanta Legal Aid Facebook page if you want to review anything that we have talked about today. Please remember the disclaimer that we gave at the beginning, and that is the facts of everybody's case is going to be different. Where you are, the county that you're in, if you're in different states, there's just a multitude of factors that can impact. So certainly make certain that you are reaching out to an attorney if you need to seek further advice. Our number here at the downtown office of Atlanta Legal Aid is 404-524-5811. You can certainly call us to go through an intake, and if you qualify for our services, we can certainly try to provide some advice on your legal issue. Our email address is atlantalegalaid.org. And we certainly want to thank you for spending a part of your afternoon with us and giving us an opportunity to provide you just some very general basics on custody and child support and legitimation today. And with that, I think we are all done.
All right, thank you so much.